Good afternoon, everyone, and thank you very much for joining me for this afternoon's webinar on international care cases post-Brexit. It's not quite the same as seeing you all in a room, but I'm still delighted that you're all here. If I just start sharing my screen in a minute, just bear with me, and you should be able to see my slides. The slides, incidentally, will be shared, distributed after the talk today, so no need to take copious notes. If you want to ask any questions, I'll hopefully leave a bit of time at the end. Please feel free to pop them either in the chat or the Q&A box, and I'll try and remember to look at all of that. Now, let me just see if I can actually do the technology. Here we go. All right, this is going to be a bit of a canter because, as you may be unsurprised to hear, there's quite a bit of material to get through. I will focus on cases that previously were covered by the rules applying to EU countries, for the obvious reason that this talk is about Brexit. The first slide just sets out what you probably all know very well, which is the international sorts of issues that arise in care cases. The first question usually being jurisdiction, and courts have at least now got very good at asking that question, or at least in theory, because it's in the standard form CMO. There are also questions of transfer, and then of course the knotty question of where the child should be placed, and in particular assessment of carers who may be outside the jurisdiction, the availability of orders, and finally the question of recognition and enforcement. The broad outline of the talk, as I've already said, it's focusing on cases involving EU countries. Insofar as it's specific, which rules apply to a particular case is the first question, then a summary of the rules, and it will come as no surprise that the two regimes I'll be looking at are Brussels II revised and the 1996 HAGUE Convention. And then I'll hope to leave a bit of time for some practical considerations, at the risk of sounding like I am teaching my grandmother to suck eggs. And I apologise in advance for that, if that's what I end up doing. Now, the question of which rules apply, we, as you no doubt all know, had the jolly implementation period until 11 p.m. on the 31st of December 2020. The EU regulations continue to have effect until then, the snappily entitled IP completion date, the even more snappily entitled European Union Withdrawal Agreement Act, Section 39, and Council Regulation EC number 2201/2003, to give it its reference, or Brussels II revised, as I'll call it, was revoked on IP completion day by Regulation 3 of the Jurisdiction and Judgments, Family Amendment, etc. EU exit regulations, the exit regulations. As you can see, lots of snappy titles going on here. The revocation does not apply in relation to proceedings before a court seized before the IP completion day. That's Regulation 8 of the exit regulation. And seized means a court is seized at the time when the document instituting the proceedings or an equivalent document is lodged with the court, provided that the applicant has not subsequently failed to take the steps the applicant was required to take to have service effected on the respondent. Essentially, in care proceedings, I think that means any proceedings that were issued before IP completion day, i.e. before 11 p.m. on the 31st of December last year, still, the Brussels II revised still applies. So that may continue to be the case for a bunch of cases that were started last year, particularly since at least my experience has been that there are a fair few cases that have taken longer due to COVID, and of course international cases always taking longer anyway. But I would expect the cases to which Brussels II revised applies to dwindle steadily over the next 6 to 12 months and peter out at some point completely. I will proceed on the basis that most of you, Brussels II revised is probably old news, so I'll try not to spend too much time on it, but just by way of an overview, and so you have it in your handout of the slides when it gets distributed. Here are the crucial provisions. First of all, the scope is in Article 1. It doesn't apply to decisions on adoptions, measures preparatory to adoption, or the annulment or revocation of adoption. And you may remember the case of Re N, where first the Court of Appeal looked at the question of whether that meant that care proceedings where the final care plan was for adoption didn't fall within Brussels II revised, and the answer was no, they still fall within it, and that wasn't disturbed, that decision, when the case went to the Supreme Court on a slightly different question. Jurisdiction is then dealt with in Article 8, the general rule on jurisdiction based on habitual residence, with which you're of course all familiar, not least because that's the wording included in the standard draft CMO. There is also in Article 9 a provision for continuing jurisdiction for 3 months after a change of habitual residence for the purpose of modifying a judgment on access rights, and jurisdiction is retained in cases of wrongful removal or retention, although there are a bunch of conditions on that I don't have time to go into. There is also a jurisdiction where the parents have ongoing matrimonial proceedings between them and have accepted jurisdiction of another member state. And finally, and importantly, jurisdiction based on the child's presence, where habitual residence cannot be established, or where the child is a refugee or internationally displaced. And certainly I've had a few cases where the court has decided it's just not possible to establish the child's habitual residence, and it's assumed jurisdiction under Article 13. Another important article is Article 15, which enables the transfer to the court of another member state with which the child has a particular connection, if the court considers the other court would be better placed to hear the case and where this is in the best interests of the child. And in Re N, again, the Supreme Court was very clear that this means the transferring court as well as the receiving court have to consider the child's best interests, and the child's best interest is not the same question, or what is in the child's best interest is not the same question as whether the other court would be better placed to hear the case, although clearly there is going to be a bit of an overlap. Articles 17 and 19 deal with what should happen if there are potentially 2 courts who may have jurisdiction. I think I will skip on to the next one. Again, a very important article, which no doubt many of you will have come across, which is Article 20, that deals with urgent cases. And it says the provision of the regulation shall not prevent the courts of a member state from taking such provisional, including protective measures in respect of persons or assets in that state as may be available under the law of that member state, even if under this regulation the court of another member state has jurisdiction as to the substance of the matter. And the circumstances in which we've come across this most frequently, no doubt, is in a case where there's an urgent need to take protective measures, such as an urgent ICO or an EPO, and there either isn't time to work out who has jurisdiction, or it's fairly clear that another country may well have jurisdiction, but the court in England and Wales still has the power under Article 20 to make protective orders, which cease to apply when the court of the member state with jurisdiction has taken the measures it considers appropriate. Another important point, of course, recognition and enforcement are dealt with. Article 21 makes it clear that a judgment given in a member state is recognised in another without any special procedure being required. There are grounds, forgive me, for non-recognition, certain circumstances in which it may be argued that a judgment shouldn't be recognised in another member state, and procedures for declaring enforceability. So the scenario is essentially it's recognised without further ado, but there is a procedure for enforcing it. Another very important point, particularly when it comes to having assessments of family members, including, I suppose, occasionally parents who are outside the jurisdiction, is cooperation. Article 53 deals with the designation of a central authority. Article 54 is clear that the European Judicial Network should be used for cooperation, and Article 55 sets out cooperation on cases specific to parental responsibility, and that's very broad provisions about cooperation between states. It includes provisions about placement of a child in another member state at Article 56, and provisions about working methods, including languages in which authorities are communicating, can be communicated with, and also the principle that each authority bears its own costs. Having cantered through Brussels II revised, I'll now move on to the 1996 Hague Convention, which is basically what will apply to any case that is issued after the IP completion date, so from essentially the 1st of January of this year onwards. Again, to go with the snappy titles, its full glory is Convention on Jurisdiction, Applicable Law, Recognition, Enforcement and Cooperation in Respect of Parental Responsibility and Measures for the Protection of Children. The European Council authorised ratification or accession by all EU member states except Denmark in June 2008, and in fact Denmark also has ratified, and the 1996 Hague Convention is in force in Denmark, so no worries if you have a Danish case, the Hague Convention still applies. It came into force in the UK on the 1st of November 2012. In the UK, the 1996 Hague Convention is supported by the Parental Responsibility and Measures for the Protection of Children International Obligations, England and Wales and Northern Ireland Regulations 2010. Another snappy title, the 2010 regulations, and procedure is dealt with in the Family Procedure Rules 2010, Part 12, Chapter 6, Section 2, insofar as applications are concerned, and Part 31 deals with the registration of orders. Looking at the contents of the convention itself then, the scope is dealt with in Article 3. The convention applies to measures directed at the protection of the person or property of a child at which the convention is aimed, including the placement of the child in a foster family or in institutional care, or the provision of care by kafala or an analogous institution. The supervision by a public authority of the care of a child by any person having care of the child. So there's very little doubt, if anyone needed confirmation, that it does apply to care proceedings. Article 4 sets out the matters to which the convention does not apply, and this very much mirrors what Brussels II revised does. In fact, Brussels II revised was very much based on and modelled on the 1996 Hague Convention, hence a large amount of overlap. But it's probably fair to say that Brussels II revised is 1996 Hague with bells on, clearly based on the fact that it concerned members of the European Union, where there was a greater degree of integration and cooperation than can perhaps be expected of the rather diverse selection of countries who've signed up to the 1996 Hague Convention. Anyway, to get back to what is not included, decisions on adoption, measures preparatory to adoption, or the annulment or revocation of adoption. And also, this is again the same for Brussels II revised, measures taken as a result of penal offences committed by children. In case you were wondering and very familiar with the 1980 Hague Convention, the definition of child under the 1996 Convention is from the moment of birth until they reach the age of 18 years. So unlike with 1980 Hague, where the cutoff is at 16, here the cutoff is the same as it is in our domestic law, so it's 18. and importantly, it is from the moment of birth, not pre-birth, which may be of importance in cases where you're doing a pre-birth assessment, for instance, and considering proceedings from right from when a child is born. Now, Article 5 is the article that sets out the ordinary, if I could put it that way, jurisdiction that happily is also based on habitual residence, and so the same law on determining a child's habitual residence applies as we've all been used to applying under Brussels II revised. So that is happy news. And in fact, I think much of the case law that applied to Brussels II revised is very likely to continue to apply, although REN that I've already mentioned highlights, I think, quite a potentially important difference. Another difference here is that there isn't a provision equivalent to Article 9 of Brussels II revised, where the original state retains jurisdiction during a 3-month period for the purpose of modifying a judgment on access rights. So jurisdiction basically transfers with habitual residence under the 1996 Hague Convention. Article 6 deals with jurisdiction based on presence, and again, that is happily parallel to Brussels II revised. It applies to refugee children, children who, due to disturbances occurring in their country, are internationally displaced, and children whose habitual residence cannot be established. So again, very much parallel. The provisions for transfer happily also exist under the 1996 Hague Convention. Well, I say happily, it often probably gives us a bit of a headache in proceedings to think about whether they should be transferred or shouldn't be. The authority, what Article 8 says, is the authority of the contracting state, which has jurisdiction under Article 5 or Article 6. So based on habitual residence or presence, if it considers that the authority of another contracting state would be better placed to assess the best interests of the child, may either request that other authority directly or with the assistance of the central authority of its state to assume jurisdiction, or suspend consideration of the case and invite the parties to introduce such a request before the authority of the other state. There is no requirement for the transferring court to consider whether a transfer would be in the child's best interests. And on the basis of what the Supreme Court said in REN, that may make a difference, a significant difference in some cases, where perhaps the court might have decided on the Brussels II revised that the other court is better placed, but nonetheless a transfer is not in the child's best interest. I think the answer here may then be, if the other court is better placed, then there is more reason to consider a transfer, although it is still discretionary. The Article 8 sets out the contracting states whose authorities may be asked to assume jurisdiction. They are a state of which the child is a national, a state in which property of the child is located, and a state whose authorities are seized of an application for divorce, etc., in regard to the child's parents, and a state with which the child has a substantial connection. So where Brussels II revised just went with the connection, the 1996 Hague Convention sets out some specific circumstances in which another court can be, or another authority can be approached. If this is the case, the authorities may proceed to an exchange of views, and the authority to whom the request is addressed may assume jurisdiction if it considers that this is in the child's best interests. So here it is the receiving court that makes the best interest decision. The authorities of both states must agree to the transfer, and it seems that transfer of part of the case or a transfer on a non-permanent basis is possible under this article. We then have Article 9, which is the mirror image, as it were, of Article 8, so where Article 8 deals with, for the sake of argument, us sending cases to another jurisdiction. this allows another jurisdiction to ask us to accept cases. Again, it's only if both states agree and the procedure is much the same. And indeed, it's the same as it is under Brussels II revised. It's FPR 2010 rules 12.61 to 12.68. In England, an application for transfer of the proceedings to another state must be made to the court hearing the care proceedings using the Part 18 procedure, and an application for the court to request the transfer of proceedings from another state must be made to the High Court without notice to any other person. Cases of urgency are dealt with in Article 11. This says, in a case of urgency, the authorities of any contracting state in whose territory the child or property belonging to the child is present have jurisdiction to take any necessary measures of protection. Now, none of this, I think, is defined, but it is. I'll come on to in a moment to what that may cover. The jurisdiction is concurrent with and subordinate to the jurisdiction of any contracting state that has jurisdiction on the basis of habitual residence, and any measures taken will lapse as soon as the authorities with primary jurisdiction have taken the measures required by the situation. Article 12 says something very similar about provisional measures. And it says authorities in a contracting state in whose territory the child or property belonging to the child is present have jurisdiction to take measures of a provisional character for the protection of the person or property of the child, which have territorial effect limited to the state in question, insofar as such measures are not incompatible with measures already taken by the authorities which have primary jurisdiction. And again, any measures taken will lapse as soon as the authorities with primary jurisdiction have taken the measures required by the situation. The subordinate legislation in the UK, the 2010 regulations that I referred to at the beginning of this section, make it clear that in cases where Article 11 or Article 12 applies, the local authority may apply for an interim care or supervision order for a limited period, and the order will last until the authorities in the contracting state that has jurisdiction have taken the measures required by the situation, or measures taken in another state are recognised in England and Wales. There's no requirement for a care plan that is specifically spelt out in the regulations. The proceedings are specified, and so a guardian must be appointed. So it's sort of parallel to Article 20 on the Brussels II revised, but also subtly different, and there are some specific provisions about going about it in the regulations. Scenarios where there are two states with jurisdiction are dealt with in Article 13. The authorities of contracting state must not exercise jurisdiction if at the time of the commencement of the proceedings, corresponding measures have been requested by another contracting state with jurisdiction at the time of the request and are still under consideration, unless the authority first requested has already declined jurisdiction. I think translated into plain English, that basically means if a child arrives in this jurisdiction and, for the sake of argument, acquires habitual residence, the court here must not do anything if there are ongoing proceedings in another state where the child previously had habitual residence or which had jurisdiction for another reasons such as on the basis of presence there, unless that other authority has declined jurisdiction. Article 14 tells us that any measures taken by a contracting state that has jurisdiction remain in force even if there is a change in circumstances that, for instance, has meant the child is no longer habitually resident in that country or is no longer present there, as long as the new authorities which have gained jurisdiction under the convention have not modified or replaced them. As the convention says on the tin, it also deals with applicable law. I think I will skip over this because it probably doesn't crop up all that often, but the nutshell is it's domestic law in the contracting state with jurisdiction that is applied, and that clearly is a happy circumstance for all of us who don't have to get our heads around other jurisdictions' laws. There is a bit of an exception for parental responsibility, and the headline summary, I think, is a generous approach to parental responsibility if it was in existence under the law of the previous country of habitual residence. It remains in existence, but it may also be gained in this country under the law of this country. It can, however, still be modified or terminated by protective measures here. In other words, if the court here makes a public law order that interferes with parental responsibility, that is perfectly fine. Recognition and enforcement. Article 23 says that measures taken by the authorities of a contracting state shall be recognised by operation of law in all other contracting states. So it's automatic. There is no need for any formal application for simple recognition, but as with Brussels II revised, there is a need for formality when it comes to enforcement. There is a bit of case law here to tell us that measures are, the word measures is interpreted broadly and doesn't just include court orders, but also undertakings, and that's the case of Re-Y. There are, as under Brussels II revised, grounds on which recognition may be refused, and in fact they are pretty much the same. These are 6 grounds on which recognition may be refused. The first is under Hague that essentially the authority who took the measures didn't really have jurisdiction to do so. The second is that except in a case of an emergency, the measures were taken in proceedings where the child didn't have an opportunity to be heard. The third is similar to that, except it's a person with PR not being heard, again, except in the case of an emergency. The fourth ground is if recognition is manifestly contrary to public policy of the requested state, taking into account the best interests, best interests of the child. It's, I think, quite a high test, this manifestly contrary. If the measure, fifth ground is if the measure is incompatible with later measures taken in the non-contracting state of habitual residence of the child, where this later measure has been recognised by the requested state, and if the procedure provided for in Article 33 has not been complied with, is the sixth ground on which recognition may be refused. And Article 33 deals with placement in another contracting state. I'll mention that in a moment. If Article 26 tells us that if measures taken in one contracting state and enforceable there require enforcement in another contracting state, they shall, upon request by an interested party, be declared enforceable or registered for the purposes of enforcement in that other state, according to the procedure there provided in the law of the latter state. And that is your FPR. Part 31. A declaration of enforceability or registration may only be refused for one of the 6 reasons set out in Article 23(2). So the 6 grounds that I have just read out, and refusal is discretionary, not compulsory. Article 29 deals with cooperation, says each state must, a contracting state must designate a central authority. In England, that is the Lord Chancellor, who delegates his day-to-day duties to the International Child Abduction and Contact Unit, ICACU, with which you are no doubt all familiar. Article 30 says that local central authorities are required to cooperate with each other and promote cooperation among competent authorities in their states to achieve the purposes of the Convention. They shall, in connection with the application of the Convention, take appropriate steps to provide information as to the laws of and services available in their states relating to the protection of children. And in particular, under Article 31, central authorities should take appropriate steps to facilitate communications and offer the assistance provided for in Articles 8 and 9 in Chapter 5. So those are the provisions that deal with transfer of proceedings, where you may recall there was a requirement for there to be an exchange of views between contracting states or the authorities in contracting states before a decision is made whether to transfer the proceedings or not. The central authorities must also facilitate by mediation, conciliation or similar means agreed solutions for the protection of the personal property of the child in situations in which the convention applies. And they must provide, on the request of a competent authority of another contracting state, assistance in discovering the whereabouts of a child where it appears that the child may be present and in need of protection within the territory of the requested, state. So these are compulsory, as it were, forms of cooperation under the 1996 Convention. Article 33 deals with placement in another contracting state, and it is very much parallel to the equivalent provisions in Brussels II revised, in that an authority seeking to place a child in care in another contracting state must first consult the central authority or other competent authority in the other contracting state and submit a report on the child together with reasons for the proposed placement. And the decision to place may only be made if the requested state has consented to the placement, taking into account the child's best interests. The Hague Convention also gives us another form of compulsory cooperation, as it were, under Articles 36 and 37, which applies in cases where the child is exposed to danger, or the contracting state, the authorities in contracting state A, in which measures for the protection of a child have been taken or are contemplated, consider that the child is exposed to serious danger and they are informed of that child's presence or change of residence to another state, whether that's a contracting state or not. Those authorities are obliged to inform the authorities in the other state about the danger involved and the measures that have been taken or are being contemplated, except under Article 37, where to request or transmit information would, in the opinion of the competent authority, be likely to place the child's personal property in danger or constitute a serious threat to the liberty or life of a member of the child's family. Now, I don't suppose that this is extremely likely to be very high up the agenda in any cases where the child has moved to an EU country, but it's still there and it may occasionally apply for whatever reason. These, as I've said, are the mandatory, as it were, forms of cooperation, and there are also non-mandatory forms of cooperation under the Convention. Cooperation is contemplated but not a mandatory requirement in these situations where the central authority of a contracting state with which the child has a substantial connection may request the central authority of the state of habitual residence and in which the child is present to provide a report on the situation of the child and consider the need to take measures for the child's protection. That's Article 32. Under Article 34, a competent authority may, if the situation of the child requires it, request any authority in another contracting state to communicate any information which it has, which is relevant to the protection of the child. And I suppose that is the article that may well cover such things as assessments of carers in other jurisdiction. There's also provision for assistance in implementation of measures of protection under Article 35 and assistance for a parent seeking contact. Now, where under Brussels II revised, there was explicit mention of the European Judicial Network, there isn't explicit mention in the 1996 Hague Convention of the International Hague Network of Judges, that should say. But if you look at the website of the Office of the Head of International Family Justice, they very clearly list 1996 Hague cooperation as something with which they may be able to assist. And just for those interested, the head of international family justice at the moment is Lord Justice Moylan, and the deputy head is Mr. Justice MacDonald. Now, after that little canter, and this is for future reference more than anything that you may wish to absorb now, but I hope this table will come in handy as you're trying to navigate your way through 1996 Hague versus Brussels II revised. It just sets out as closely as possible the equivalent provisions. If anyone is really interested, I have made a longer, much longer version of this where I've set out in greater detail for my own purposes the differences and similarities between the two conventions. So anyone who is interested in that, just drop me an email and I will try and provide it to you. That leaves hopefully a few minutes to look at practical considerations. And as I've said, I'm very aware that I'm probably teaching my grandmother to suck eggs and stating the obvious to a large extent, but I have recently had a number of cases with international dimensions, and there has been a great deal of delay and a great deal of frustration in certainly a number of them. So coming out, well, one of them being a case where on the 1st of April last year, the court decided to transfer the proceedings to Romania under Article 15 of Brussels II revised, and the children travelled to Romania, I think, around about the 9th of April of this year, and it took over a year to get the children there, clearly partly because of COVID, but also because the children didn't have valid passports or other travel documents, and it transpired that the consent of both parents was required to get those passports, and the local authority in fact couldn't do it even though it had an interim care order and had parental responsibility. And then all of the above was complicated by the fact that the children's father sadly passed away, and so proof of well, his death certificate was required so that the mother alone was able to consent to the documents being obtained. And it was just a never-ending catalogue of frustration and delay. And so the lessons that certainly I have taken from that case and many others is that the earlier international issues are identified, the better. And in addition to the new rules that are likely to come in, or what is coming out of the public law working group, that the child's birth certificate should always form part of the documents available at the start of proceedings, I'm inclined to advise that it's a good idea to make sure right at the start you know where the children's passports are, if they have them, or other ID or travel documents, where they are, how long they are valid for, and whether any steps need to be taken to renew them or obtain them, particularly in cases where there is an international element and there may be a proposal that the children travel outside the jurisdiction. So just to look at the list then, very important, and you will know this no doubt, that is the early identification of international issues, particularly potential carers outside the jurisdiction. Getting contact details early. I know sometimes social workers can be reluctant to do that because parents may be reluctant to provide them. And I think it's really important that it's explained clearly to parents why that question is being asked and how it can avoid delay. And due to often cultural differences, that is not a straightforward job to do, but the earlier it's addressed, the better. And I certainly have been guilty of forgetting about it or not focusing on it as much as I should have, which then led to delay much later down the line. Getting details of where in the other country the family lived. If you make a request of ikaku, they ask for the address where the family last lived in the other country, because it helps speed up matters. consider making an early initial inquiry of HAGUE by email if you're not entirely sure about what the arrangements are going to be for assessment of family members, for instance. And it's probably worth considering getting in touch with CFAB as well. As I've said, check nationality and immigration status pre-proceedings, ideally, and ascertain the existence, validity, and whereabouts of travel documents, and obtaining passport or other ID document numbers, which again will help with getting information from the other jurisdiction via HAGUE. And this again is very much an ideal. Getting documents translated immediately or as soon as possible will also avoid delay. For those representing parents, it's a tricky one, but it would be helpful to focus parents' minds early on, in all cases, of course, on alternative carers and providing details, which sometimes can be the difficulty. And again, it's worth just checking with them what the deal is with nationality, immigration status, and whether there are any travel or ID documents, who has them, whether they're valid, and what the process might be. And of course, those representing the child or children, it's worth there keeping an eye on all of the above and reminding the parties that they really need to focus on these issues and encourage parents, representatives to get details. In fact, encourage parents, and sometimes it can help, in my experience, if what's been being said by the social worker forever, if that's repeated by the guardian, how important it is. That, I think, takes me to the end. There's then some slides with just references and resources, which hopefully will come in handy and will help you as you navigate your way through these new and interesting, fun times. Now, I don't see any questions in the pop-up chat or question and answer. If anyone has any questions, please feel free to pop them in those boxes. I have been given 2 questions in advance of today. One came from Scarlett Johnson, who asked about service and has given me a beautiful headache because that is not something about which I have thought in any great detail. And she quite rightly says that service out of the jurisdiction can be a bit of a headache, and she says she's aware of the 1965 Hague Convention on Service Abroad of judicial and extrajudicial documents in civil or commercial matters, but has been told that can take ages. I've done a little bit of research on this, and rather joyously, the outline available on the Hague website says that says 75% of requests are executed within 2 months, which may be sufficient in a civil dispute about land or such like, but will quite clearly not wash in care proceedings with a 26-week limit. The only vaguely helpful thing I can think to say is that the foreign process section at the RCJ should be able to help with what can be done. And Article 10 of the Service Convention does say that provided the state of the destination does not object, the convention does not prevent service, for instance, by post. But I'm not sure how compatible that in fact is with our domestic rules in the family procedure rules at 6.40 to 6.48. So I'm terribly sorry, Scarlett. I'm faffing a little bit, but hopefully pointing you in some directions that might help. And I'm happy to pop this in an email to you. There is then a second question from Carrie Hopton about no recourse to public funds and what the impact of Brexit is on that. I'm not entirely sure that I completely understand the question, but I guess the short answer is EU citizens have lost their special status, and there may in future therefore be EU citizens who do have no recourse to public funds. A little search on the internet on the gov.uk website brought up public funds, migrant access to public funds, including social housing, homelessness assistance and social care, which is guidance for Home Office staff dated the 17th of March of this year. And that may be quite helpful in trying to work out who does or doesn't have access to public funds or recourse to public funds. Now, I've just seen there is a question from Sarah Benfield. Thank you very much, and hello, Sarah. If a child is moved to Poland under an SGO, if the mother wants to seek to discharge the order, does she have to apply in Poland or back to the original court in England? I'm very much juggling this in my head, Sarah, so it may well be that we should communicate directly about it more. But it seems to me that under the provisions of 1996 Hague, the SGO will remain in force until such time as under Article 14, until such time as the new authorities which have gained jurisdiction under the Convention have modified, replaced or terminated it. I think that means she could and maybe should apply to the new, if the child is now habitually resident in Poland, she probably should apply to Poland, because I think under the Hague Convention, England no longer has jurisdiction if the child is physically present in Poland and has acquired habitual residence there. But that's very much me thinking on my feet. So it comes with all sorts of caveats, but feel free to drop me an email. All right, if there are no further questions, then I think I will probably bring this session to an end, and thank you all for joining me. And I look forward to seeing all of you in real life sooner rather than later. All right, thank you very much, and I hope you have a good afternoon.